Court is now in session.
Okay, thank you very much. Welcome, counsel. I'm sure you all are now familiar with the video conferencing, but just a reminder that when you're speaking, you should be unmuted, but when your opponent is speaking, you should be muted. Please also remember you should not take any pictures of this or any recordings, audio or video. Also, please recall that when you reference the record, we would appreciate a record cite, and that rebuttal is for rebuttal only. And with that, we will proceed with case number 20-30126, Theriot versus Building Trades United Pension Trust Fund. And we'll begin with Mr. Staub.
Good morning, Your Honors. Harry Staub on behalf of appellant Deborah Theriot. And Happy New Year to you all. Hopefully it will be. I don't, there's a lot of points in here that are complicated, I guess, as in all ERISA cases. So I would like to get right into the one that I think drives the most serious errors in the case. And that would be the court's characterization of the March 2nd, 2018 letter as a substantially compliant ERISA denial of Audrey Hammond's claim to lump sum retirement benefits attributable to the long-term employment of her husband, Robert. Cases that are using substantial compliance with ERISA procedures as a rationale for barring the claimant's receipt of benefits on grounds of failure to exhaust are relatively few. Both the court below and counsel for the fund relied on this court's unpublished decision in McGowan versus New Orleans Employers International Longshoremen's Association. Judge Higginson, you participated in that decision, and it might therefore be familiar to you. Notably, however, this was an unpublished decision. Most importantly, though, the case bears no resemblance to the letter that is at issue here. I, once upon a time, had the privilege for quite a few years to serve as general counsel to a health plan. We conducted live hearings and issued letter decisions that clearly demarcated a notice of decision. And then after the decision notice, we followed it up with a clear explanation that if the claimant disagreed, then of course he had a right to seek review of the plan decision, and then he had a right to get the plan materials and all of the documents that were relevant to the claim at no cost, just as the reg requires. If the claimant appealed, we typically followed up to see if there was any additional evidence that he wanted to submit on review. The letter at issue in McGowan followed the same format with one caveat that was seized upon here. That was when it reached the section of explaining the claimant's rights to seek review of any disagreement with the plan decision, a provision which the letter clearly laid out. It then referenced as an attachment a review procedure that was described on the attached pages. And that procedure in McGowan is much different than what happened here. The March 2nd letter that was issued by the fund in this action is an aggressive summary of legal position that was in response to a perceived legal threat. The letter doesn't even attempt compliance with ERISA requirements, let alone substantial compliance. In its preliminary paragraph 1, counsel aggressively advises counsel for Ms. Theriot that she lacks standing to assert her claims. There, of course, is no provision in a plan document that denies derivative standing to the daughter of the deceased plan beneficiary, and none is cited in the letter.
Mr. Staub, it seems to me that the failures of the building trades to comply with all of the rules could lead to one of two arguments. One argument is, therefore, they lose on the merits. The other is, therefore, any problem that Theriot, any failure to exhaust any procedural violation she made should be excused. Which argument are you making?
We're actually going to make three that tie into this letter. We think that the letter should be adjudged inadequate to do anything other than, cause her to be able to go directly into her litigation. And I don't know then if it would be a remand or something the court would want to consider on its own, but the judge did express some opinions in his original decision on the motion to dismiss that suggested that he thought that the claim was otherwise meritorious. I suspect that, that merits decision would really have to be a remand. We also think that the whole exhaustion, the need to exhaust should be out the window via the deemed exhaustion doctrine, or because this circuit incorporates the procedural irregularities into its analysis of whether the proceedings below were full and fair, and that in turn is addressed as part of a benefit claim.
Mr. Staub, I just want to, I'm trying to kind of summarize. It's my understanding that your argument is not that their mess ups mean the case is over, they lose on the merits. It's that their mess ups mean now we get to the merits.
That's correct.
Did Theriot's mother, in fact, have the right to the lump sum, and her death before it came in the mail did not change that? That's the merits of the case as I see it. And you're just saying we need to get that case decided.
That's correct, John.
Okay.
But you're open, but that question's important. So the remedy, though, who decides the merits? There's significant law that would also allow her to be remanded back to the administrator and then to get the final administrative review that she didn't timely. In other words, it's not necessarily deemed exhausted, end of story. I've seen our case law and most other circuits say the alternative is just get back to where it was truncated.
Some cases do remand to the plan for further proceedings, and there have been cases in this circuit where the procedural irregularities have been deemed so pervasive that the court just went on ahead and ruled on merits.
And you're open to either one?
I'm certainly open to either one.
Okay, back on whether or not there was substantial compliance. Obviously, you're nice to observe that I was on the McGowan panel, and the similarity there is that there was an attached, clear and unmistakable statement. But the difference, I think, is that the letter there sort of endorsed it, whereas the letter here is in tension with it. And I noticed Judge Afric below the district court did say that when we look at these, we look at the full set of communications. So is that sort of black letter law that we aren't just looking at the attachment and the plan itself, which is usually the linchpin of ERISA, but we're also looking at the letter as to how it might interact with the plan?
I think you have to look at the letter to see if it accomplishes everything that the claimant is supposed to receive notice of. I mean, otherwise, the claimant just gets lost in a proceeding and doesn't really know where to go.
Does it matter that this was not a lay claimant alone? This claimant had counsel?
I don't think so. And the reg doesn't make that distinction. And at the time that as you know from the record, this individual changed counsel. I think she was, kind of lost as to where to go with this or what to do. And she was being told, by non-ERISA counsel that she had this letter rejecting her claims, and what was she to do with it?
Now, you recall the district court said, well, this, quote, discouragement argument is best understood as the plan simply protecting its position, not trying to confuse her or create uncertainty as to notice.
Well, and they certainly could have accomplished that by setting out the letter in a different fashion. The preservation of rights doesn't have to be a dictation to a claimant that, you have no claim. if you do go back to the whole history of communications and you take the first denial from April 2017, that's all of 3 lines long, by what is perhaps, the largest and most sophisticated plan in the country, that certainly knows better. I can't help but come away with the impression that, well, this is how you get rid of these claims. This was a plan that was marked as endangered by the DOL. This is a plan that I think is taking every step that it possibly can to save money. And so you get a kind of a shoo away little 2-line letter that doesn't have all the legalese, that's going to advise the claimant of her rights. And then, you ease your way on into, other more substantial documents, just in case you have to recharacterize them down the line, which we believe is what the fund did here.
I know there isn't much law in 1133, as you stated, at least as it pertains to full and fair notice of exhaustion requirements. But remind me from your brief, what is the best case on this, that where a circuit court has looked at it and said, a reasonable interpretation wouldn't be understood by the beneficiary, this isn't enough?
Let's see, I think I have the case.
If it doesn't directly come to mind, we've got your brief. I just was wondering if you did have one, because there's a lot of ERISA law, but I like you, I couldn't find too much on what's substantial compliance as a matter of law when you have attached the plan that does clearly state it in the attached whatever section 2.3, but then the letter accompanying it discourages or even says you can't access it.
Well, so of course, there's quite a bit of conflicting, jurisprudence in ERISA. I think that's part of what makes it so complex to deal with. I did want, because the issues are complicated and we're gonna run out of time. I have a couple of things. So the other point to answer the question about how this all ties into the March letter is that, the March letter is also a good takeoff into why the production of the administrative record was so important here. I haven't been involved in a case previously where the administrative record was not instantly popped into the record. Here, that wasn't done. And so we end up not having a definitive statement by the plan, a la the introduction of these records, not only of the little bits and pieces of correspondence addressing the claim internally, but most importantly, we don't get a plan document that they're saying is the plan that applies here. And we also don't get the collective bargaining agreement, which we have made a large deal of, because the collective bargaining agreement is defined in both the plan and the summary plan description as one of the basic plan documents. There are a couple of provisions that I wanted to draw to your attention that are in the plan document that suggest that had that inquiry been able to go forward with the administrative record all being filed, we would have found out that we indeed did not have the correct plan at all. So if you look at Article Roman numeral X, Section 12 of the plan document, which is ROA 153, is the start page, and plan document page 86, that Section 12 reads, except as otherwise provided herein, the provisions set forth in this restated plan are applicable only to individuals who are active participants as of December 6th, 2017. Well, Mr. Hammond was quite deceased, retired and deceased by then, and active participants, as you would expect, are defined to be those participants who are still working and contributing to the plan. The section goes on to say, inactive participants' benefits shall be determined under prior plans except as specifically provided herein. Now, that's not an academic provision when you take it alongside of the section that is on page 101, which coincidentally is right after the review pages, but excised from those pages in the production that was given to the claimant. And that section is entitled non-forfeitability. And that, of course, says the benefits to which a participant is entitled under this plan upon his attainment of normal retirement age are non-forfeitable. The benefits to which a surviving spouse is entitled shall likewise be non-forfeitable. So this is what I would have expected to find for a pension plan, unlike the welfare benefit plans I dealt with. Pension rights get frozen at a point in time, which is marked by the retirement. So we don't even know, given that provision, whether or not some other plan was really the governing plan, and did it even have the same exhaustion and review proceeding that was to be followed, because that suggests on its face that we don't even have the correct plan.
When in the record did your client, with you, prior counsel or anyone, raise the discouragement argument? That, so you understand my question? Because if I remember a footnote in Judge Afric's reconsideration order, he said, this was not even raised until after I dismissed the case. Do you remember that footnote, and is he correct?
That the letter was an active discouragement?
Yeah.
That permeated all of our oppositions, from the original motion to dismiss to, the motion for reconsideration certainly has it in.
Okay, so it's been there throughout.
It's been there throughout. We, of course, at the time of the original motion to dismiss, couldn't have suspected that he was going to recharacterize that letter. So most of the argument was in terms of the prior denial in April 2017.
Okay, you saved some time for rebuttal, Mr. Staub.
Thank you.
Please remember to mute yourself, and we'll turn to Mr. Ho.
May it please the court. So let me start by addressing Judge Higginson's last question. The issue of the failure of the discouragement was not raised until the motion to dismiss had been granted. Let me talk about the April 2017 letter for a second. Why that is.
Yeah, but you did hear his answer was that your client pretty much has consistently stated that's because they think the original 2017 denial was the one that was compliant.
But that wasn't a position we even talked in response to the motion to dismiss. Our position in response to the motion to dismiss was whatever defect there was cured by the March 2nd, 2018 letter.
The trouble with that is it seems counterfactual because the March 2018 letter refers approvingly and incorporates the 2017, right? The whole premise of the March 2018 letter is that you don't have standing and you're out of time to do anything because you were denied a year ago.
Right, but that is just a reservation of right to raise the defense. And the question that you raised previously, though, was about what were the arguments that were made in the original motion to dismiss. And the argument that was made was the March 2nd letter was adequate, and that imposed exhaustion requirement. In fact, the April 2017 letter is immaterial to the consideration of the exhaustion requirement. It's for this reason. Imagine for a second that all that happened in this case is there was a March 29, 2017 request to convert a benefit, and the fund did not respond at all until the March 2nd, 2018 letter. Under controlling Fifth Circuit precedent, even if there was a delay in processing the claim, that is not the type of harm that can just excusing the exhaustion requirement. That's the Bourgeois case, 215 Fed 3rd 481, that the plaintiff has not attempted to distinguish or limit in any way in their reply brief. So the exhaustion requirement comes down to a simple question. Was that March 2nd, 2018 letter adequate and comply with ERISA?
But the difficulty I have with accepting that is a layperson, and I think the plan is a fiduciary, and we look at how would a layperson interpret the communications. And so, yeah, I may agree with you that if it had been just the 2018 letter, but that letter couldn't even have been written as it was unless there'd been the insistence that the 2017 had sort of ended the story.
I don't agree with the characterization there was an insistence. Because if you look at the 2018 letter, specifically at the top of page 2, what it says is the pension fund reserves the right to assert that the January 5, 2018 letter was an untimely appeal and therefore judicial review is barred.
Right, but the carryover, the first time the plan attachment is even mentioned is on page 2 at the top. And it's attached not saying, here's how you can exhaust. It's attached to support the plan's argument that she has no remedy anymore. She's too late.
I disagree, Your Honor. After the reservation of defense, what the pension fund then did was spend almost an entire page outlining why on the merits the claim should be denied. And then they attached the entire appeal procedure. There's no reason to attach the appeal procedure. The claim's already barred. The reason they attached the claim procedure was that despite a reservation of right to raise a defense in the case of judicial review, there was a further administrative procedure available, and the attachment was for the purpose of notifying Theriot of that availability. And McGowan is directly on point here. The difference between McGowan and here is in McGowan, the entire summary plan description was attached to the denial letter. Therefore, the fund had to tell the claimant where in this large SPD the claim procedures could be located. Here, the pension fund only attached the specific provisions that govern appeal. So there was no reason for the claim letter to tell Theriot exactly where to find the appeal procedure.
Well, I may be repeating myself, but I'm just looking at the letter now. The sentence that refers to the attachment, as in McGowan, starts out by telling her she's too late. And then the sentence after it says, this forecloses the ability. So why wouldn't a layperson think, okay, I've lost it, it's too late. They think I was over with in 2017. And they're attaching proof to show that I didn't then seek timely exhaustion.
So first off, Theriot was represented by counsel at the time. If you look, and even in October and November 2018, when the Theriot sent in, current counsel sent additional letters, they asked, what step of the administrative procedure are we on? Theriot didn't abandon the claim in response to this letter at all.
I think that's your best argument, actually.
In addition to that, if you look at the plain language of the letter, what it says is we reserve the right to raise this timeliness defense, and if the defense had merit, judicial review will be barred. And then the pension fund went on to discuss the merits of the claim and attach the appeal procedure. This is a reservation of defense. The pension fund had to do that in order to preserve the defense for judicial review.
You would most forcefully resist deemed exhaustion, but what's the real resistance to allowing her to have the administrative review that, had she been alert, if we assume your letter and all your communications were substantially compliant, she would have gotten? What's the harm to that?
Because the March 2nd letter was ERISA compliant. And because of that, and because it was ERISA compliant, there is an exhaustion requirement that needs to be enforced here under the Fifth Circuit.
Mr. Ho, let me tell you what bothers me about your arguments in this case. It is, we messed this up, but that's okay. She messed up, not okay. Why is it okay for you all to mess up, but not for her to mess up? Why can't we just go back to where we should have been had everybody done what they were supposed to do, which, like Judge Higginson said, is the administrative procedure?
Because this court's decision in Wade says this: appellant is not entitled to ERISA compliant denial at every step of the procedure. is entitled to one ERISA-compliant denial. If it fails to timely request further review after receiving the ERISA-compliant denial,
Wade is about trying to win on the merits, as I read it, that the appellant was trying to win on the merits based on the mess-ups by the appellee. And I'm saying that's not what they're doing here. They're not saying we now get the money, send us the check. They're just saying we get to be heard on this, on the merits. So why not that? It seems to me everybody messed up, right and left in this case. Why not start over and decide the merits?
Because Wade says you're only entitled to one ERISA-compliant benefit denial.
But Wade wasn't about this situation.
That was received.
It wasn't about this situation. So that's, I really don't see that there's a case that says we'll let the ERISA pension fund, the insurer, the whoever mess up, but we sure as heck won't let the insured or their beneficiary mess up. And that seems inconsistent with the fact that ERISA very much limits the rights of beneficiaries and insureds and pensioners and so on. You don't have bad faith cases. You don't have all the whole litany of things that you have, say, in Texas. And so to me, the idea that we're just going to construe everything in your favor and everything against her seems highly inconsistent with the fact that you already have a lot of things in your favor.
But the fund really didn't mess up in a material way here. And the reason for that is under Bourgeois, you look at all the communications between the fund and the claimant. Here, because a lawsuit wasn't filed, you can look at all the fund's communications to Theriot to say, has an ERISA-compliant benefit denial been issued here? The answer to that is yes. Regardless of what the April 2017 letter said, the March 2018 letter was an ERISA-compliant denial, thereby imposing, thereby triggering the 60 days for Theriot to file an administrative appeal.
You're not disputing the district court's statement that 2017 letter was not compliant.
I am not. But do you also look at the context of that, though? As well.
Yeah, but do you also therefore then, I agree with you, and that's candid, but it's also not disputable that the 2018 letter still tries to incorporate it. That alone is pretty confusing.
The 2018 letter reserves the defense based on the 2017 letter, but then proceeds to consider the claim on the merits and attach an appeal procedure, which I will argue is perfectly compliant. The court also has to consider the context of the 2017 letter. This is a very unusual circumstance where the beneficiary dies and the fund is communicating with family members of the beneficiary.
Yeah, so I wanted to ask you about that. Was the 2017 letter correct on the merits? Or was the money owed had it been requested properly as you view it?
I don't think the issue matters, but I think the answer is yes. The 2018 letter was correct on the merits because when you're converting, because this case involves the conversion of a benefit from a monthly payment to a lump sum. May 1, 2017 was designated as the day of the conversion. The plan was certainly written in a way that could be construed to say that when you're evaluating the amount of the lump sum, you're evaluating the amount, the actuarial value at the date on the day of the conversion. On the date of the conversion, Mrs. Haman was already dead. The monthly benefit was worth nothing. Therefore, the lump sum is also worth nothing. Therefore, the benefit denial decision on its merits was correct.
You're looking at the May 1, not when she requested it. Okay.
Right. I think the plan is generally.
And that's based on what section of the plan?
Based on the plan language that governs conversions, also based on the discretion given to the administrator to interpret the plan. The plan doesn't specify on what day you measure the value of the benefit. It certainly allows an administrator to use her discretion to say we use the conversion day, which Mrs. Haman did not object to measure the value of the benefit.
And don't you think that's what we should send back, that question? Because it seems to me the way y'all phrased it to her she would think that once she asks for it, she's entitled to it. And that she doesn't have to live long enough for it to sort of arrive in the mail.
I don't think sending it back is appropriate here because the March 2nd letter, after it gave her the decision on the merits, it then attached the full appeal procedure. Under that appeal, what that appeal procedure says is if there's an initial benefit denial, you have 60 days to appeal that decision. If there's a first level appeal denial, then you have to file a second level appeal within 60 days. Regardless of whether she was confused or not, she should have understood from reading that document, she has 60 days from the receipt of the March 2nd, 2018 letter.
But why wouldn't she think it was 60 days from April 2017 and she didn't have a time machine?
Because if that was the case, then there was no reason for the pension fund to attach the appeal procedures if the appeal was already in time.
Yeah, it's to show, you messed up.
But that's not the reason. The reason was to explain to her where appeal rights were. That's why the full appeal procedure was attached.
And what would tell her that? What would tell her that you're not applying that to the 2017, but only to the 2018? What sentence?
Because
I don't mean in the attachment, I mean in the letter.
Right. The March 2nd, 2018 letter would not have considered the claim on the merits if the fund's sole position was it was time barred. The time bar reference was a reservation of defense, not the ground for denying the claim. The entire second page talks about the merits.
She's just supposed to infer that. You're not showing me a sentence where that's clear.
Well, the second way that's clear is because the top page 2 says we reserve the right to assert the claim what the request for benefit was untimely. It doesn't say it's untimely. It just says we reserve the right to assert is untimely, thereby making it very clear it's a reservation of defense, not a claim on the merits that was the reason for denying the claim.
Okay, and to get back to a conversation you had with Judge Higginson, is there some separate standard in ERISA for someone who has a lawyer, someone who doesn't? Is there some case that says you treat them differently in how letters are written and so on?
Well, I think exhaustion ultimately is a prudential standard. So you look at what should the claimant have understood and how the claimant should have proceeded. That the claimant had a counsel certainly provides additional reasons why they should have understood there was an appeal available and that it had to be taken in order to exhaust administrative procedures.
Well, I'm just going to carry that out one more piece. If we really are looking at what really happened, do we look at the concept of counsel or do we look at the actual counsel? And my experience is most lawyers are totally unfamiliar with ERISA. And does that matter? Mr. Staub sort of alluded to that. Does that matter if we're looking at the full picture? Does it matter that you have a lawyer who really doesn't understand that ERISA is quite different than a lot of other areas of insurance, et cetera?
If that was in the record, I think the court potentially could. The problem here is there's simply nothing in the record about Roger Javier's experience or lack of experience in ERISA matters. So whatever Attorney Staub may say about Attorney Javier's lack of experience, that simply is not supported by this record.
So you're saying that we should have a presumption that if we're looking at this prudential, we're looking at the whole picture and all of that, so I'm walking with you down that path, that the presumption is that attorneys are very familiar with ERISA, even though I know that presumption to be wrong.
I'm not saying there should be a presumption. I'm saying is if Theriot wants to argue exhaustion should be waived because I wasn't represented by experienced counsel, it's Theriot's burden to produce evidence in the record that establishes that.
All right, I understand that. Okay.
Besides McGowan, just because your time's running low, what substantial compliance case would you say is closest, where a court has said this type of letter, not just the attachment, is substantial compliance, telling a beneficiary their time limits?
I would argue that what we have here is not substantial compliance, it's full compliance. If you look at 2560-503G, everything that's required by that regulation is in the March 2nd, 2018 letter. There's nothing in the regulation that says you cannot reserve your right to raise timeliness defenses in a benefit denial letter.
I guess I'm just asking.
I'm rejecting, no, I disagree with the framework that there's only substantial compliance here.
Okay, let me, you probably know the cases pretty well. The First Circuit Fortier decision, the 11th Circuit Watts decision, they're both about courts looking at the full set of communications to ask, would a reasonable interpretation by a layperson have understood there's an exhaustion deadline? Do you favor either of those two cases? Do you have any other case where a court said, this letter should have been clear enough to the average layperson? What's the case you think is most factually similar?
It would be, within the Fifth Circuit, it would be the Bourgeois case.
The what case?
The Bourgeois case, 215 Fed.
Okay. Yeah. Thank you.
But even even beyond that, again, this is not substantial compliance. This is full compliance with the requirements of 2560 503G. And given that Theriot did not file a lawsuit before March of 2018, you have to look at all the communications between the fund and the claimant. And here, the March 2nd, 2018 letter is compliant and therefore trigger the exhaustion requirement. And regarding whether or not the estate was entitled to documents during the litigation, remember from the very beginning of the case, there was a motion to dismiss that was pending. And when that motion to dismiss was granted, the benefit denial is no longer before the court. So even if there is a requirement to file an administrative record in a benefit denial case, this was never a life benefit denial case because first the motion to dismiss was pending and then the motion to dismiss was granted. Whether or not there were the pension fund had any obligation to produce documents, information to support refute other aspects of Theriot's claim, plainly governed by the federal rules of civil procedure. And there's no dispute that the state in this case has neither challenged nor has waived the right to challenge the magistrate judge's denial of his motion to compel. The pension fund, the state is not entitled to a single additional piece of information in this case because the motion to compel was denied and that denial wasn't timely appealed. And we stand on the briefs for the remaining issues that were raised by Theriot on this appeal.
All right, thank you, counsel. We appreciate your arguments. And we'll now turn back to Mr. Staub for his rebuttal.
Judge Haynes, to answer your question about the merits to begin with. So the plan's position is that despite the fact that the plan language says that she can reduce her benefit to a lump sum benefit at any time is the operative language, that because the plan had already paid a monthly benefit in April, that the next benefit wasn't going to come due until May 1st, and therefore there was no current actuarial value. We think that's nonsense on the face of it. The actuarial value is the remaining stream of payments when the right is exercised, which is the at any time. So she exercised on when they received the letter on April the 4th, and certainly there was a remaining value to be calculated at that time. With respect to the issue about the changes of counsel, so when this letter arrived and it was sort of the end of predecessor counsel's representation and I received the case, I personally, being a very experienced ERISA counsel, did not know what procedural context that I thought this case was in. And that's why I both filed the lawsuit and wrote the plan as well and said, hey, if you guys want to go ahead and go through the administrative proceeding, I don't think you've concluded it properly, and you can go ahead and do that. I'll do that. I'll participate either way. Of course, I never got any kind of...
So you wrote the November 2018 letter?
I wrote the November 2018 letter, yes. And that was after suit had already been filed, though, a couple of days after suit was filed.
But I mean, to be a little persnickety, you didn't say, wow, that letter back in April or March was confusing. You just said, I want my administrative review. Because
I never construed it as anything other than a response to the threatened litigation from the Javier firm, which I think was one proper construction of this plan, was to say that because that was a vested non-forfeitable benefit, that it was extra ERISA contractual, and so he demanded payment. And this was, no, you don't get payment, and all the reasons why.
All right.
Thank you very much, John.
Thank you. Thank you both sides. We appreciate your argument. The case is under submission, and this concludes the arguments for the day.